If you're an architect that's thinking about entering into a B101 2017 agreement with your project owner client, I think you're really on the right track because the B101 2017 is a great document for a wide variety of projects from the architect standpoint, whether it is a commercial project or whether it is a very substantial residential project, whether it's public, whether it's private. The B101 2017 is really the flagship owner-architect agreement that the AIA creates. There are a few that are more complicated. There are a few that are a little bit less full, and it's certainly the case that I will sometimes use those other documents if the project is appropriate for using other agreements. But the B101 2017 really tends to be kind of the Goldilocks document from my standpoint. It's one of my absolute owner-architect contract forms. And I am going to dedicate the second half of this video to going through its 13 different articles and giving comments about things that architects should think about in each. I'm going to start off by making some just general observations about the document that elaborate on some of the concepts that I've talked about previously in other videos, including my general video on the B101 2017 that I just got finished recording. This is one of those agreements that assumes the basic project delivery method where you, the architect, are going to get hired first. You're going to get hired by the owner. You're going to have a separate contract with the owner. That's what we're talking about right here, the B101 2017. And later, the owner is going to enter into a separate contract with the contractor. And the B101 2017 and its companion, the A201 2017 General Conditions document, which is 38 pages long and is incorporated by reference into the B101, sets out some really basic assumptions about what the architect is going to do. They're going to do SD and DD and CDs, and there may be some help in the procurement phase or bidding phase, and then they're going to do CA, construction administration, and it's that A201 general conditions document that is really going to speak to what your obligations are in the construction administration phase. So I cannot warn architects in stronger terms that if you are going to use the B101 2017, you must understand that 38 pages of your contract are the A201 2017 general conditions, which are incorporated by reference into the B101 2017. And frankly, in any arrangement where you're using AIA contracts and you have the owner separately hiring you, the architect, with a owner-architect agreement over here, and the owner hiring the contractor with a separate owner-contract agreement here, the general conditions document is going to apply. Okay, and I cannot overstate the importance of you realizing that even if an owner doesn't email one to you and say, what do you think about it? It's part of our contract. Even if you were never asked to look at one or negotiate one, it is absolutely incorporated by reference and included in your B101 2017. It contains the word architect or some form thereof, architect, architecture, I want to say 317 times. So you got to read the B101 2017, which is a description of your business deal with the owner. What is your fee? What is your scope of services? You must read it with this other document, the general conditions document, which isn't so much about your business deal with the owner as it is about how you and the owner and the contractor are going to play nicely in the sandbox together when you're in the construction phase. What are the assumptions about reviewing payment applications, about reviewing RFIs, reviewing submittals, shop drawings? What is your role in making site observations? What is your role in punch listing and substantial completion and final completion? And it's really not just about what you're going to do in those phases. It also has essential concepts in there that you can't do without. So as an architect, you got to pay close attention to the A201 2017 general conditions when you're using the B101. The basic assumption that the AIA has is that if you use a B101, then you are going to take the entire A201 general conditions off the shelf, and every time, the more than 300 times that the word architect comes up, you are going to do all those architect-y kind of things that are described in the general conditions document. So you're going to want to have your eyes on it. It's really a great document, the general conditions document, that pairs very nicely with the owner-architect agreement, whether it's the B101 or some other form of AIA owner-architect agreement, because it really has a fair allocation, I think, of risk that puts guardrails up around what it is that you're supposed to do as the lead design professional, what you're not supposed to do. It talks about safety not being something that you're responsible for, because obviously you're not on the site every day. It draws proper lines of demarcation between, your responsibility for being on the site and keeping your eyes out on the final construction and whether it's going to conform with your issue for construction documents and your design intent as compared to the means and methods that are used to get there. And they place the B101 puts responsibility for means and methods and a wide variety of other things on the contractor. So I like the general conditions document. Please don't make the amateurish assumption of assuming that if you sign a B101 2017 that the A201 general conditions does not apply. It absolutely does, even if no one emails you one, even if you've never seen it, even if you've never signed it. It actually doesn't call for your signature because it is incorporated by reference in the owner-architect agreement and the owner-contractor agreement. And because the B101 envisions that your design phase is going to come first, and then a contractor is going to get selected second, or at least the construction contract is going to get signed second, because your design has to advance to a point where a contractor would be willing to agree to scope of the work, fee, schedule, because the design phase comes first under the basic assumption of the B101. The general conditions document, if it is edited, it is generally edited in the second half of the project when the contractor is negotiating their agreement with the owner. And it would make sense, obviously, for you to not be able to edit the general conditions document too much at the outset of your relationship with the owner, because it might be the case that your design is a year away from something that could be bid by a contractor, and there may not be a contractor in the picture. And so it would be weird for you and the owner to negotiate the general conditions document a year before there's a contractor involved in the project. So it is typically something that a lot of architects make the mistake of thinking that it's not part of my contract because I never saw one. No. The idea is that if you sign a B101 2017, you are going to do all the architect-y kind of things that are signed to you in the A201 general conditions. And in the event that your scope of services is such that you're not going to perform any work in the construction phase, for example, that's the sort of thing that you can clarify in the B101 2017. Rather than edit the A201 general conditions document, you can just include in the B101 2017 whatever scope assumptions are appropriate for you to round out your business deal with the owner. You may have your work done, for example, when you stamp the documents and a construction permit is issued. You could put language in the B101 to that effect. In the event that you don't make any of those changes, the B101 is going to assume that there are the traditional phases of design, SD, DD, CDs. There's a procurement phase that may have you involved or not involved in a bidding process, in a negotiating process, helping the owner evaluate the bids or the contractor proposals that they receive. There's a pricing exercise that I think is really important for design professionals to understand that is going to happen throughout the course of the SD, DD, CDs, and onboarding a contractor phases. Now, some of you are probably thinking, oh, pricing exercise, well, design professionals don't do cost estimating. And I think that that's right. I think that a well-advised design professional, unless they've got a cost estimator sub-consultant, which is not something I love from the standpoint of representing my architect clients in the first place, unless that's the case, I don't think that architects should be in the business of doing cost estimating for owners, because architects, unlike contractors, don't keep their eye day to day on price fluctuations of commodities like steel and what labor prices are, right? That's what contractors do because they're responsible for bidding. But still, the basic assumption of the B101 2017 is that you as the architect are going to get a target budget from the owner that you are going to try to hit, and there is going to be a pricing exercise at the end of these phases. So You get your budget from the owner, or at least the target that they want to hit. You come to some understanding with the owner about what their program is. You make sure that it has reasonable alignment with the budget that they're trying to hit. Then you do SD, and then the AIA B101 2017 assumes there'll be a pricing exercise. So at the end of SD, the owner should go to their cost estimator or their contractor who's providing pre-construction services for an estimate. It's not going to be a detailed enough design to do a takeoff estimate or anything, but conceptual estimating, cost per square foot, things of that nature. And at the end of SD, in the event that your design is trending to a point where it's going to be too expensive for the owner because maybe there was scope creep, maybe they asked you to throw some additional stuff in since they gave you their target budget, or maybe it's just fluctuations in commodity prices, steel goes up because there's a tariff or something like that, you at the end of SD can kind of reel your design back in and do a little bit of value engineering unless the owner is inclined to increase their budget that they gave you at the outset. Then the same thing repeats at the end of DD. You do the pricing exercise and you calibrate the design and what the owner is asking for and what you're providing with what we think it's going to cost, and that cost data is provided by somebody other than you. It's provided by a cost estimator or a contractor typically hired by the owner. Same thing at the end of construction documents, when the permit set is prepared, when CDs are issued. And then there's another costing and pricing exercise when the contractors are close to being on board. Whether it's a bidding process on a public project where you're going through formal bidding and you finally get to the lowest reasonable responsive bid, or whether it is a private bidding process where it's a private owner that's just got 2 or 3 contractors submitting, proposals, or whether it's a negotiation between one contractor and the owner about what the price of construction is going to be. When you get to the end of this procurement phase, in the event that your design has produced a constructor that is wanting a lot more money than the owner wants to pay in order for them to build your design, the idea is, and this is a huge oversimplification of design professionals, so it's much more nuanced than this. The idea essentially is that unless the owner wants to increase their budget, then you're going to do a value exercise for free, but then that is the extent of your responsibility. So, the B101 2017 is a little bit vague on this, but the idea generally is that you can't be sued for over-designing. And this is one of the things that I love about the B101 2017. I think it's fair for owners and architects alike because it's logical. It assumes there's going to be give and take throughout, SD, DD, CDs, budget adjusting, value engineering. So I think that it's a great document, and if you're thinking about using the B101 2017, you're on the right track. It provides a variety of different options for your compensation as an architect. It could be hourly billing, which I love. It could be stipulated sum or fixed pricing, which I also love. I love both of those because they're easy to administer and they don't tend to lead to a lot of disputes with owners over what your fee is. You also could use the B101 2017 to be paid as a percentage of the ultimate construction cost or cost of the work, although this is by far and away my least favorite way of architects getting paid. There are so many nuances around, if you get paid a percentage of the cost of the work. I mean, on the one hand, what if the owner just decides they're not going to build the project? If your contract says that you're going to get a percentage of what the construction cost is, if somebody wants to really interpret the contract narrowly, if there's no construction costs, then you're, 3 or 4 or 5% of zero is zero and you get no fee, which is obviously not fair and not what is intended. And so, if you are going to get compensated, whether it's through the B101 2017 or any other owner-architect agreement, and you're going to get paid as a basis of a percent of the cost of the work, there's so much nuance that calls for custom edits here. What if the owner, for example, decided that they only wanted to go forward with half of what you designed? Does that mean that you don't get paid for the other half? Well, if you're not careful about making sure that there's intelligent custom edits in your contract, regardless of whether it's a B101 2017 or another AIA contract document between owner and architect, or really any other form, a non-AIA agreement, something that I would create myself, an EJCDC form, a consensus docs form, whatever it is. If you're going to get paid a percent of the cost of the construction, the cost of the work, you better be really careful as a design professional to have a whole lot of nuance around making sure that whatever happens, you're going to get paid. So, generally, we've got, this give and take in the design phase, SD, DD, CDs, bidding, value engineering, aligning price and quality, and then we get to the construction phase. And of course, the B101 2017 assumes that the architect is going to protect the owner in the construction phase. And this is really the main point of the tripartite method of project delivery that I was discussing before. In other words, when the owner has a separate contract with you over here, this is the B101 2017 or any other owner architect agreement, and a separate agreement with the contractor over here, the assumption in these AIA contracts and in many other contract forms is that you as the architect, you are the protector of the owner. You are going to be the one that is going to walk the site and say that it doesn't look like construction is proceeding in a way that is going to result in a finished product that is consistent with your design intent. This, combination of the B101 2017 and its companion, the A201 2017 general conditions, are the documents that are going to talk about what is your role in walking the site and evaluating the work, in reviewing submittals, in reviewing RFIs, in reviewing requests for substitution, in reviewing and certifying payment applications, in the punch list phase, in terms of certifying final completion and substantial completion. Like the B101 2017 assumes that this is part of your scope of services, architects, is that you're going to provide this fulsome set of construction administration services in order to protect the owner essentially from the contractor. We don't state it as such, but the owner's relationship with the architect and the owner's relationship with the contractor, it really kind of sets up an intentionally adversarial relationship between the design team and the construction team for the benefit of the owner. And your half of this is to essentially watch the hen house and make sure that the fox isn't making off with the chicks. You are there to protect the owner. This is baked into the B101 2017. Of course, it can be changed, right? I talked about how there's nothing that stops an owner and an architect from modifying the scope of services that the architect is going to provide in the design phase. That is perfectly fine. They can modify their scope of services in the construction phase too. You can get rid of CA entirely, but if you're not going to do that, if you are going to provide construction phase services, then again, you better watch that A201 2017 general conditions, because it says the word architect in it more than 300 times, and it has some essential terms in there that you can't live without. And of course, it also talks about things that you're going to do and what you're not going to do. So it would be a bad idea for you to not know what those things are. So even if the owner doesn't email you a general conditions document to look at, you should assume whenever you're using a B101 2017 or any other AIA contract where the owner separately hires you over here and separately hires the contractor over here, separate contracts, right? Not design build, but instead separate agreements between the construction team and the design team with the owner. Your basic assumption is that you should look for that A201 2017. It's not always the case. There are some owner architect agreements that have those general conditions like terms kind of baked into the owner architect agreement, but the B101 is not one of those documents. It goes hand in hand every time with the general conditions. And there's stuff in there that's really important for you. And I'll tell just a quick story about some language in Article 11 of the General Conditions, which talks about insurance, which saved one of my architect clients from a really difficult situation. And there's actually this case that I'm going to talk about, this dispute that I'm going to try to cover very quickly, actually made reported case law in the state of Illinois. And so you can actually find this case if you want to read all the details in the state of Illinois. But the bottom line is that we had a situation during construction where there was property damage. It was due to a a weather type event, and it wasn't noted until after construction was finished that this created a problem with geotechnical, civil, structural, and what we had is the slab on the building, collapsing and subsiding, and we had like a real problem. And so there was a big lawsuit. I think there were 8 or 9 different parties involved, and the owner and the contractor and the design team and the geotechnical people, the people that did the proof rolling, civil. Everybody was fighting over. Well, it's not my fault. It was something else. It was a weather event. It was an act of God. No, it wasn't. It was a bad design that couldn't anticipate it. You know what? I looked at all this noise and all this nonsense, and I said, guys, there are terms in Article 11 of the General Conditions document which mean that none of these parties can be sued because the owner agreed to allocate this particular risk solely to insurance with terms in the General Conditions document in Article 11 that says that in situations like this, nobody can sue anyone, and it's the owner's property insurance, there's builder's risk insurance that is going to step in and deal with the problem. And so I went to the owner's attorney and I said, hey, we should have a mediation and we should do a settlement because you're not going to like what's going to happen when we bring a motion that says your whole case should get thrown out based on the language in the General Conditions document. And I couldn't persuade him. I took him to lunch. I tried to persuade him. He didn't listen to me. We went ahead with our motion. We won. My architect client for sure got off scot-free. They were dismissed. There wasn't any argument about whether they violated the standard of care or did anything like that because there was language in Article 11 of the General Conditions document that was really important that my client couldn't live without that said that they get out of this dispute. It went up on appeal and the appellate court agreed with the trial court. This is law in Illinois, and this is just one example of why if you are an architect that is going to use an AIA, owner-architect agreement, with minor exceptions, you need to know what the A201 General Conditions says. It's got 38 pages of essential terms. It says the word architect more than 300 times. If you do not pull one off the shelf and understand that it is incorporated by reference into your B101 2017, you're basically doing this. And that is a really bad idea for having win-win outcomes. Something else that is probably the most important thing that I like to think about when I'm negotiating any owner-architect agreement, including the B101 2017, is insurability. In other words, you want to make sure that there aren't edits put into the B101 2017 by the owner that are going to spoil your professional liability insurance. The idea is essentially that if you were to come up and shake an owner's hand and say, I'm going to do some architecture for you, you're perfectly covered by your professional liability insurance because it covers architects if they make mistakes in doing architect-y kind of things. But when you in an owner-architect agreement start getting into other terms and you start talking about like guaranteeing certain outcomes, or you're going to achieve lead and you're not careful about the exact words that you use, or you agree to defend the owner in the event of claims, or you make certain agreements to pay the owner's attorney's fees. There's a whole bunch of ways that you could stick other words into your owner-architect agreement that are beyond the basic sort of handshake, I'm just going to do architecture for you, owner, that are not necessarily architectural kind of things. It's just stuff that you agreed to by contract. And your insurance, your professional liability insurance, which of course I've not seen, I'm making a generalization here, but if it's like every policy I've ever seen, it's not going to cover you for that extra stuff. It's only going to cover you if you violate the standard of care in performing professional architectural services. And so when you start getting into edits, and there are a lot of custom edits that are necessary in the B101 2017 to right size it for the parties in the project, and I'm going to get into what those edits are in a second, at least at a high level. When you start getting those edits in from the owner, you got to watch out that they have not destroyed your professional liability insurance coverage by sticking some of the magic words into the contract that are going to wreck your insurance. This is the reason why every architect, everywhere, every time before they sign a contract, they need to show it to their insurance broker, and they need to say, hey, the promises that I'm making here about the insurance that I'm going to provide, this is consistent with my insurance program, right? I'm not going to violate the contract the instant I get done signing my name on it, right, Mr. Or Mrs. Insurance Broker? And this is a service that good insurance brokers provide. But a lot of them, and really like, all of the good ones, are also going to look at an agreement like this, and they're going to flag for you things which give them concern about maybe wrecking the insurance, creating an uninsurability situation. And again, this is one of those things where it's not like I'm saying this to you as architects and I'm whispering different things into the ears of my owner clients. Regardless of whether I represent the owner or the architect in negotiating any owner-architect agreement, whether it's a B101 2017 or anything else, my interests are the same. Owners don't want to destroy the architect's professional liability insurance any more than an architect does. The thing is that oftentimes the real estate attorneys who are not construction attorneys, they're not design and construction attorneys that do what I do, they're real estate lawyers that do other things. They don't understand this concept, and so they'll come out of the gate and they'll stick things in your contract that are going to blow your insurance up. And I, every week, have to get on the phone with real estate attorneys and attorneys from other areas that are not familiar with this area. And I have to say to them, listen, in the event that the architect actually makes a mistake, because there's no such thing as an architecture firm in the world that's got a vault with $1 million in cash in the back, or a bunch of gold bars. This professional liability insurance policy that the architect brings to the table is the only substantial asset that you're going to be able to draw upon, owner, to be made whole if there's actually a legitimate design error. So you as the owner don't want to screw this insurance up. It exists for you. It exists to cut a check for you to settle the claim in the event there's actually a problem. And so you as an architect, when you start getting into the way to customize the B101 2017, particularly when you've got an owner involved and the owner's got a lawyer, particularly if the owner doesn't do what we do at my firm specifically, someone who's not a design and construction attorney, but is a adjacent attorney, maybe a real estate lawyer, they might put some words in there that are going to mess your insurance up, and you got to be really careful to make sure that you don't let that happen, because that's the kind of thing, if you don't have insurance, that can put a design firm out of business. So the B101 2017 is insurable off the shelf. When you go to customize it, you can spoil your professional liability insurance. That's maybe the most important thing that you need to make sure doesn't happen. But then there's a variety of project-specific and party-specific customization, If this is an existing building and there are hidden conditions, there needs to be some language around that. If this is a building where you are only going to be working on a couple of different floors, there needs to be language about the fact that, you don't have obligations with respect to accessibility violations in the lobby. What if you pull the door open and it requires tight pinching and grasping, and it's an AIA violation, but you're not working on the lobby or the facade or the front door, you're working on the 10th floor. What happens if you walk in the door and you are aware there's a violation? There needs to be custom language to protect you. What happens if you are designing right up against a property line? What kind of shoring has to happen? Is it means and method? Is it your design? Where's the line of demarcation? Compliance with certain laws about digging near property lines. These are all things that I like to spot in what I call an issue spotting exercise. When I've got an architect that comes to me and they say, I need a contract drafted, I'll say, give me the information about the project. I'll spot all the project issues and I'll customize the document with custom terms for that project that might not be necessary on another project to protect you, the architect, and to create clarity around what obligations the owner has, in addition to you with regard to some of these project-specific issues. There's also party-specific issues. Maybe it's the case that you are going to fully engineer the design and that you as the lead design professional, the architect, are going to hire the mechanical engineer, the structural engineer, the electrical engineer, the plumbing engineer, and you are going to have fire protection engineered underneath you. But it may also be the case, and it probably is the case, that MEPFP is not designed by you or your subconsultants, but rather by design build contractors under the GC. And if that's the case, there needs to be language, custom language in the B101 2017 or really any owner architect agreement that kind of explains that there will be design provided by the construction team and explain what are your responsibilities with respect to that. So You're going to have party-specific, project-specific customization of any contract, including the B101 2017. You got to make sure that it doesn't wreck your professional liability insurance. It is in your interest that that happen. It is in the owner's interest that insurance doesn't get spoiled. And so now I kind of want to pivot to the second half of this video, which is a little bit long, but having covered the kind of basics about the B101 2017 and why I like it and when it is going to be used, I want to pivot and give you a little preview into some of the stuff that comes into my head when I'm representing architects and I'm negotiating a B101 and specifically putting in those project-specific and party-specific and state law-specific edits. So let's go through the 13 articles of the B101 and let me give you a little bit of a window into my thought process when I'm representing architects. I want to caution you that if you were to listen to what I'm going to say on the rest of this video and say, I've got the blueprint for negotiating every owner-architect agreement I'm ever going to do from now on because Jeremy gave me everything I need to know, you are going to have terrible outcomes because we are not even scratching the surface here. You are going to get about a 10,000th of what I think about here. And so what I'm going to do next is not legal advice for you. It's probably not appropriate for every project, but hopefully this will help you to kind of get your gears turning a little bit about some of the stuff that you and your design attorney can think about when you're putting those custom edits into the B101. So first, we'll talk about Article 1 in the B101, which is styled as initial information. And here, I like to say from the standpoint of architects that more is more. This is where you talk about the owner's program. And, it's often the case that architects will give short shrift here. They'll say, what's the owner's program? Oh, it's to design and build a junior high school. Well, what kind? How many floors next to existing buildings? The more that you could put in around what the owner's program is, the clearer it is going to be later in the event that there's scope creep, or if there are, and you're looking for additional services, you can harken back and you can say, look at the initial information in the contract. It's changed because the owner had, eyes that are bigger than their budget. There was scope creep. Or you could say, I can't be liable for that thing that happened over there because I've got a really clear description of what it is that I'm doing and what I'm not doing. And it's very clear that that stuff over there is not part of what I'm working on. Article 1 of the B101 is also where you're going to want to talk about the owner's budget for the cost of the work. And now, critically, this is not a number that's provided by you. This is not an estimate that you're providing. This is an owner-supplied number. And if you're not really clear about what it is, if you allow it to say to be determined, you don't have a target to shoot for in terms of where you want your design to be, in terms of what it's going to cost to build. And if you don't have a target to shoot for from the beginning, you're going to run into all kinds of trouble if you wind up in the middle of the design phase or at the end when CDs are issued. If you've got an owner that says, you over-designed the project, Mr. Architect, you can't harken back to Article 1 of the B101 and go, this was your budget, we designed to what the number. If it says to be determined or if it's left blank, then you're going to have to fight over the text messages and the emails and what was said in the meetings and SD and DD and CDs about the owner with respect to their budget. So just do yourself a favor. Give yourself demand from the owner a number that you're designing towards and describe in detail what the program is that goes with that. Also, this is a place where you could put in design milestones. In other words, when do you have to hit certain deliverable dates? And, it's not a bad thing for it to maybe say that there are no such dates. This is an opportunity rather than just saying leave it blank or say TBD to just say there are no critical dates. So there's a lot that you can do in Article 1 initial information. I've just scratched the surface. This is not a comprehensive list, but more is more. Do yourself the service of filling out as much detail as you can. What consultants are you going to be providing, sub-consultants as a basic service? What might you do as an additional service? What might you do as a supplemental service? Are you going to be using the AIA's digital practice documents in order to govern the transmission and use and reliance upon digital data, whether it's, BIM model elements or something else, like do yourself the favor of making Article 1 as fulsome as you possibly can. Moving on to Article 2, which is called Architect's Responsibilities. This is where the standard of care is discussed, and I think that the standard of care in the B101 2017 is just fine. I think that I could certainly live with it when I'm representing the owner, but there's definitely some custom supplements that I'm going to want to put in there that explain a little bit more about the difference between a design error versus an omission. There are a number of ways that I'm going to like to beef up the standard of care. There are different types of mistakes that a design professional can make. If you got the structure wrong and it's not noted until construction, brace yourself for a big claim. And hopefully you've got a good sub-consultant agreement with your structural engineer sub-consultant, and you can share in the responsibility with your sub-consultant. But like if you make a different sort of a mistake, as opposed to an error like that, if you just have an omission, if your hardware schedule doesn't contain any doorknobs, for example, it's a different sort of a thing, because you really ought not to become responsible for paying the owner for the cost of all those doorknobs, because they always needed the doorknobs. And it's not because you made a mistake. It's because people have hands, and doors have to be opened with people's hands. And so there's a distinction between an error and an omission. This is just one of a half dozen ways that I like to customize Article 2 of the B101 2017 when I'm talking about the standard of care and the architect's responsibilities. But there's a lot here that you could do to get into the agreement, which, as someone who often represents owners in these negotiations, I'm going to agree to a lot of this stuff because it's fair and it's not of great concern to me. You can do yourself the favor of protecting yourself in the event of a claim by beefing up Article 2. I mentioned, I think earlier, about the criticality of talking to your insurance broker every single time that you sign any contract, whether it's a sub-consultant agreement or whether it's an agreement with an owner or any other agreement that you're going to sign. If it's going to talk at all about what you're going to do, you got to make sure that you get the benefit of your insurance broker's review. They'll flag for you things that might be uninsurable. You got to get the benefit of the insurance broker's review in terms of the promises that are being made by the insurance that you're going to carry, the insurance that other people are going to carry. And I wanted to stop and mention that as part of my edits to Article 2, not necessarily because I'm always going to insert tons of insurance edits here. I would just say that when we talk about standard of care and architect's responsibilities, the number one thing that you can do as a design professional, beyond talking to a design attorney like me, is make sure that your insurance broker has blessed every contract that you sign. And I mean every contract you sign before you sign it. Article 3 of the B101 2017 is called Scope of Architect's Basic Services. It's going to assume what we talked about earlier. It's going to assume that you're going to do SD, DD, CDs, some work in the procurement phase, whether it's to facilitate bidding or to facilitate negotiation, and then construction administration. Of course, you can customize the B101, and you can say that you're not going to have any any construction phase services if that's the deal. You could also say that there's going to be a concept design phase services because it's a huge project, and maybe there's another phase of services for concept design even before SD. You can customize Article 3. Article 3 also assumes that you as the architect are the lead design professional. It assumes that you are going to subcontract out with a structural engineer, a mechanical engineer, an electrical engineer, which if that is not accurate, you're going to want to make some tweaks there. I think that it's often worth attaching another document, a scope exhibit, to the B101 2017 that's going to maybe go into greater detail. It's often the case that a lot of the content in your proposals to owners are appropriate to attach to the contract in order to better flesh out what is the scope of your basic services and what sort of services are you not going to provide. As part of Article 3 of the B101 2017, the only thing I would caution you on is that a lot of architect proposals to owners tend to be written by architects that aren't thinking about matters of insurability, and they're not thinking about spoiling insurance or not. And they tend to be salesy with a lot of promises about the owner being happy and about everything that you're going to do to make the project go well. And so if your proposals have that kind of language in it, it's not the right kind of thing to attach as an exhibit to the B101 to better describe your scope. And frankly, if your proposals have that kind of salesy, promisey, sort of like everything's going to go good for you kind of language, I think you probably need a little bit of work on your proposal writing in addition to working on coming up with a very plain, vanilla, non-salesy, clean description of anything that you're going to do that, or you're not going to do, that could be used to kind of bolster the description of your basic services in Article 3 of the B101. Other really important terms to bear in mind are going to talk about coordination. Of course, if you're going to hire all the design professionals on the project, you're ultimately responsible for their work. But what happens if the owner hires an interior designer? What happens if the owner hires civil, or geotech? What happens if there are other designers who you need to coordinate with that you've not hired, but rather were hired by the owner? What happens if there are other designers that are on the construction team? I talked about MEP, FP design build subs. What happens if there is a tenant of your owner? Maybe this is a hotel or a restaurant where, a tenant is going to have its own design team that is going to have a lot to say about your design and what it is and what it isn't. The word coordination is extraordinarily important. Coordination is a Trojan horse for liability. A lot of times when design professionals say, yeah, we're going to coordinate all the designers, what you're thinking about is you're going to send out the Zoom invites every week for everybody to talk to each other. And so you're thinking about coordination more of like, well, we're just going to sort of get everybody together to talk. But an owner's lawyer is going to say coordination means, that you're peer reviewing, the MEPFP design build subs engineering, and that you're liable for their mistakes. And, if you just throw around the word coordinate without explaining what it means and what it doesn't mean in custom edits, you're asking for trouble. And so I generally have almost a page of additional text that I like to include here that sort of explains what does coordination include, what does it not include. And I think that is just essential on all owner-architect agreements, not just the B101. We talked about the pricing exercise that is envisioned at the end of SD and DD and CDs. Watch out for some of the basic language in the B101 2017, which assumes that you may have an outsized role in producing those estimates. There's some custom edits that I think are appropriate. If you're not going to touch cost estimating, there's some additional things to massage inside Article 3 of the B101. If the project is going to be fast-tracked, in other words, if there's going to be a shovel in the ground before your CDs are issued for the complete design, there's room for some custom language to explain some of the risks that the owner is taking on there. If you're going to be asked to produce multiple drawing packages, for bidding or negotiation or fast tracking, if there's going to be, foundations and civil structural package that's issued early, whether it's for early procurement or actually shovel in the ground before the rest of the documents are fully designed. This is the sort of thing that calls for custom language because, the B101 as it is a pretty long document, particularly when paired with 38 pages of essential terms from the general conditions, the A201. The AIA couldn't cover every single possible thing in the universe that you might encounter on your project that calls for custom language in the contract, or the contract would be 100 pages long. So, if there are going to be multiple, drawing issuances for bidding or negotiation or fast tracking, you got to deal with that here. There's room for you to pay close attention to the promises that you're making in Article 3 of the B101 about how often you're going to be on the job site. If you're intending for there to be a limited number of trips to the site to observe construction, you got to watch out for some of the language in the B101 that talks about not there being sort of a limited number of trips from basic services, but instead that talks about you visiting at, quote, intervals appropriate to the stage of construction, which is just an invitation for an owner's attorney to say, well, what was going on at the time there was a problem was so critical, the architect needed to be there all day, every day, watching every nail being driven, which as an architect's lawyer, we know that's ridiculous. You're not the guarantor of construction, and no owner is going to pay you to watch every nail driven. So, how many site visits are you making as basic services? These are things that kind of call for a little bit of thought and attention when you're editing Article 3. The B101 is reasonably clear on the idea that you're not responsible for safety or means and methods, but there could clearer language inserted there. And there's also room to add some custom language in Article 3 about pay app review and the limitations of your responsibility. I could tell you as a construction attorney that represents a lot of owners on major projects, there are a lot of rules that go along with the payment process that are imposed by people other than architects that are probably not stuff that you're going to think about. What are the requirements of lenders? What are the requirements of title insurers? The requirements of escrow agents? What are the requirements of state law about mechanics liens? What kind of documents have to be collected? What is their content? There's a whole bunch of stuff that goes into my review of a payment application when I represent the owner that are just beyond anything that an architect is ever going to think about, right? I mean, you guys are generally thinking about percent complete. And that's about it. You might want to think about some custom edits in Article 3 that talks about sort of the limit of your responsibility and where the responsibility of the owner and the owner's lawyer picks up to deal with some of these legal issues. If we move over to Article 4 of the B101, it talks about supplemental and additional services, which are the two other sorts of services that you can provide in addition to basic services. I've talked about in the past how I find the concept of supplemental services to be a little confusing. We all know what basic services are. We all know what additional services are, but what's this third category? Well, the B101 2017 envisions supplemental services. It's kind of like things that are on the menu, things that you would be willing to do if the owner asks for it. It's not all that different than the idea of there being an alternate in an owner-contractor agreement, and the owner can either accept the alternate or not, and if they accept the first and the fourth alternates, the pricing is baked in, and then the project can proceed. Supplemental services are sort of the same idea. It's kind of like, take for example, like as-built drawings. Maybe your basic services fee doesn't assume that you're going to do as-builts, but maybe you'd be willing to do it as a supplemental service. Supplemental services, the default idea in the B101 is that you're going to be compensated as an architect on an hourly basis. So if you're not willing to do as-builts, you need to indicate, I won't allow this to be supplemental services because it's not on the menu. If you're willing to do as-builts as supplemental services, then you would put in that, I will do as-builts as a supplemental service, but again, you would be charging hourly in addition to your basic services fee. And there's a chart in Article 4 that I think is filled out wrong by 99% of project owners and project architects because they do not understand that chart calls for the architect to say there's certain things I'll never do, there's certain things I will do as a basic service, there's certain things I will do as an additional service, there's certain things I will do as a supplemental service, there's certain things that are the owner's responsibility. So really be careful about that chart. It's a good idea to fill in, that chart with a lot of thought and attention. If you want to talk to a design attorney about how to get that right at least once, it might not be a bad idea just so you know how to use it in the future. And then underneath the chart, after you filled it out right, there's a fill point, a big blank that calls for you to type in, what does it mean if you're going to do something that you've identified in the chart above, whether it is as a supplemental service or not, what is the description of that thing? And I'll give you an example. So, within the laundry list of possible services that you could provide as supplemental services, in this Article 4 of the B101, in this chart that is really aimed at supplemental services, there is a line that talks about, quote, facility support services, which, as someone who negotiates these contracts every single day, I have no idea what that means. And that's the reason why underneath the chart, there is a blank for you to describe what does it mean for you to provide facility support services. If you are willing to provide those, whether it's a basic service or an additional service or a supplemental service, and the box in the chart so indicates, you got to describe underneath, what does it mean? What does it mean to you and the owner for you to provide facility support services? Does that mean that you're going to be there once a week forever as long as the building's around? Or does it mean that you're on call for certain types of problems on an hourly basis? Moving on to Article 5 of the B101, this talks about the owner's responsibilities, which it's important to remember. The B101 is not just an architect agreement, it's an owner-architect agreement, and there are certainly things that an owner is going to need to do in order for the project to be successful. The owner's responsibilities may, for example, if we were thinking about custom edits, include establishment of a contingency line on the budget to deal with certain design issues. There are certainly some things to push for in the owner-architect agreement that we want the owner to do. There are more things in that category than I can cover in this video, and so again, this is the tip of the iceberg. To give you an idea, you talked about earlier what happens if your hardware schedule omits doorknobs. That is an omission, not an error. It doesn't necessarily result in it being a cost that's chargeable to the architect, even if they made the even if they're responsible for negligence in the omission. Getting the owner to pay for it is a more difficult thing unless there is, for example, as one of 100 custom edits that could go in Article 5, the concept of a contingency line item in the budget to pay for costs that flow from not design errors, but design omissions. And again, this is not an exhaustive list. There's lots of stuff to think about pushing for in Article 5 of the B101. If we move on to Article 6 of the B101 2017, this talks about the cost of the work. As some of you may or may not know, the capital C, capital W, cost of the work term of art is an extraordinarily important term of art in a variety of owner contractor agreements. I think that it is less so in terms of importance in an owner-architect agreement, but insofar as your owner-architect agreement and the owner-contractor agreement are going to kind of go hand in hand and be flip sides of the same coin, there are some things that you as the architect need to be cognizant of in this Article 6 to make sure that you're not going along with something that could be the seeds of a dispute between the owner and the contractor in the future. One of the other major things that I think that you gotta address when you're looking at Article 6 and thinking about custom edits, a major issue is who's doing the cost estimating. We all know, as people who are familiar with the way that architecture firms operate, that you are not keeping your eyes on commodity prices. What does lumber cost today as opposed to a month ago? The same way that a contractor is. And that makes sense because you're not putting bids together to do construction work. You don't know when a new collective bargaining agreement goes in place or some project labor agreement that is going to increase the hourly rate of this particular kind of journeyman plumber, but the contractors sure do. And so if you're not going to be responsible for doing any kind of cost estimating, if you're going to delegate that to a cost estimator that the owner hires or some contractor that the owner hires to provide pre-construction services, this is a good opportunity for you to get clear about that in Article 6. Article 7 talks about copyrights and licenses, in other words, design professional intellectual property. And I have an hour-and-a-half long video on my website. It's a presentation that I did to AIA Chicago on this very topic. So we are obviously, just like every other issue we're covering in this video, I'm scratching the very, very tip of the iceberg. So I'm not telling you everything that you need to know here. Don't rely on this. This is just to provoke thought. This is not legal advice for you. But, are you going to be granting the owner copyright ownership of your design, or are you just going to be giving them a license to use your design? And, a really smart Chicago construction attorney gave a talk once where he said something I will never forget that so drives home the difference between copyright and licensure. He said that if Frank Lloyd Wright gave away the copyright to the first Prairie Style home, there would be no second Prairie Style home. And I think that really captures it. If you, as the architect, are going to give copyright ownership of your entire design to the owner, then if you were in another project to use elements of the design from the first, the owner could sue you for infringing on its copyright because it owns the copyright. And if you give away the copyright ownership of things like your standard details, you don't reinvent the way you weatherproof a window every time that you do a building. If you give those standard details away accidentally to the owner by including them in the project and giving the owner copyright ownership of those standard details, technically you can't use them again. So it's a little bit, I don't know that this is an entirely accurate statement, but I think that for purposes of this video, it's good enough to say that a very watered down version of copyright ownership for the owner is a lot like a very extensive license. And so well-advised owners who typically may want copyright ownership of your design and the design of your subconsultants can sometimes be convinced to accept an exceedingly broad license. And in the event that they're strident that you have to give them copyright ownership of your design, there are ways to water down that copyright ownership quite a bit. So that you're not quite as exposed. You can include custom language in here that talks about what happens if there's unauthorized usage of your design. What if they use it on another project? What if they change it without your knowledge? Now, some of these things are actually covered by the standard text of the B101 2017, but I think that there's room to go a little further to protect architects. What about payment? Some architects' position is that you can't have any intellectual property rights in anything that I do, whether it's a copyright or a license, unless I'm paid. There's lots of room to arm wrestle with owners about, does that mean that you get fully paid, or does that mean that you get paid in accordance with what's obligated under the agreement? In terms of payments you're owed, because, fully paid is probably better for the architect. Paid in accordance with the agreement gives lots of rooms for an owner to say, well, you don't get to get paid under the agreement because you made a mistake, which means that I own your documents even though I didn't pay you. So lots of room to arm wrestle about custom language in Article 7 of the B101 copyrights and licenses. I think that it's worth thinking about whatever you're going to give over in terms of licensure or copyright. You got to think about, what are you giving? Is it everything? Is it every line that you drew on every napkin from concept design all the way through your your final Revit model in totality, or are you only going to give the owner licensure or copyright ownership of perhaps the final design in its final form that was selected for inclusion in the project, so that the other half dozen design concepts that were not accepted by the owner would be fair game for you to think about deploying in the future for other owner clients that may hire you to design other projects. And I also think that one of the most important things that architects get wrong here, and this is such trouble, is you can't overpromise the owner. In other words, you can't promise to give the owner copyright ownership of your entire set of construction documents if embedded inside them is the work product of your subconsultants, if you don't have the right to do so. If you do not have written subconsultant agreements which say that I have the right to give the owner copyright ownership of your structural engineering design or your mechanical engineering design, or that, I as the architect own the copyright to that, and therefore I can give it away. You can't promise the owner copyright ownership of your construction documents unless you're very, very careful to, carve out ownership of your designs versus the design of your subs. This is the blinding flash of the obvious. You can't give away what you don't have. If a subconsultant gives you just a license to use their documents and they retain the copyright, you can't promise the owner copyright ownership of the final CDs that are impregnated with that subconsultant's design. So you can't give away more than you got. So when you're talking about intellectual property rights, you got to be thinking about, what do your subconsultant agreements say? What do their proposals to you say? What do you have? What do you not have? And you got to make sure you don't give the owner more than you can. Article 8 of the B101 talks about claims and disputes. There's a concept that I really like to include called step negotiation. It is something that tends to come before mediation and tends to help to stamp out disputes before they become claims. So there's some custom language I like to put in there about that. I've got other videos on my website about what step negotiation is. I also am a huge fan of mediation as a method of trying to resolve disputes. It is a non-binding form of dispute resolution, which is a fancy way of saying that mediation is just an agreement to come together and to try to negotiate and to have that settlement facilitated by a third party called a mediator. If at any point you do not like the mediation or you don't like how it's going, you can make a decision to get up and walk out, and you can fight on in other stages of dispute resolution, whether it's litigation or arbitration, which are the things we really want to try to avoid if we can. So there's literally no downside to mediation. And even though if you ask 5 lawyers whether they like mediation or not, you're going to get 10 answers. I am a lawyer that likes mediation done the right way. I've got many videos on this on my website. I think it's great for design professionals. It's a way of sparing you from incurring your deductible obligation. It's a way of sparing you from a dispute that could be settled early. And so I like to jest that if I were to get a tattoo on my body, it would probably say, I love mediation. So in the claims and disputes section, I would encourage you to keep the mediation clause there. Article 9 of the B101 2017 talks about termination of the contract or suspension of the work that you're doing. There are absolutely concepts that could go in here that would customize the standard terms that would tend to help design professionals deal with these difficult situations. There's also an opportunity for you here to negotiate a termination fee. In other words, a fee that the owner would pay you if they terminate the agreement, and then a separate fee, a licensing fee, if they were going to continue to make use of your intellectual property after they terminate you. Article 10 of the B101 is entitled Miscellaneous Provisions, and this is really where I put the secret sauce in. There are all kinds of miscellaneous provisions, that I like to include. It's kind of the same thing in Article 12, Special Terms and Conditions, which I'll get to in a second. But there's definitely some miscellaneous provisions that I would add in Article 10. Article 11 talks about compensation. We talked already about how the B101 is good for stipulated sum, which is another way of saying fixed fee for your basic services. You could also be compensated on an hourly basis method. And we talked about how if you're going to be paid, if you're going to peg your fee to being a percentage of the construction costs, I think it's risky. And I definitely would not do that without getting some help from an attorney to make sure that you're protected. If that's going to be the box that you're going to check for compensation here in Article 11 of the B101. I also think that one of the most important things that an architect can think about when they're negotiating a B101 with an owner in Article 11 compensation is with respect to limited ways in which an owner can dispute an invoice. And I'm not going to go too far down that road except to say that rather than being silent on time limits and for and means by which an owner can dispute an invoice, rather than being quiet on that, I'd be very explicit explicit about it if I were you, because that can tend to help you a lot if an owner gets their nose out of joint down the road. And they want to start, holding back on paying your invoices as they get to be 2-3, months aged. Article 12 is called Special Terms and Conditions. Like Article 11, Miscellaneous Provisions, this is where I include a whole bunch of stuff. I like to think of it as my secret sauce. Limitations of liability, here are important to protect not just you as the lead design professional, but the whole design team. There's room for language that talks about product suitability. If you rely on the representations of a manufacturer that their product is, going to be ADA compliant, how could you as an architect really know if that is a misrepresentation by the product manufacturer until after it's too late, when the product is all over the building? So there's room, to have language that would talk about the extent to which you are allowed to rely on the stated and implied representations of product manufacturers regarding the suitability of their products for certain circumstances. Article 12 is a place where we could talk about hidden conditions, not knowing what's inside the walls of buildings that are being rehabilitated as opposed to a ground up project. Responsibility for code compliance. We all know that codes change, and we know that the bureaucrats at permitting agencies, whether it's, at the city level, whoever is going to be signing off, and issuing you, a construction permit, these are bureaucrats. It can be a little capricious, and, maybe after you issue your construction documents, there is a new interpretation of the code that wasn't previously given, or maybe it conflicts with an interpretation that was previously given. And I think that there's room to address responsibility for the architect to comply with the dictates of these bureaucrats, in Article 12 to get the owner and the architect on the same page. Maybe some of the most important edits in the whole of the B101 2017 relate to accessibility. Fair Housing Act, Americans with Disabilities concerns, and I like to include lots of language in Article 12, B101 2017, to protect my architect clients from accessibility related liabilities, and to help to make the point that owners have their own responsibilities with respect to ensuring accessibility for disabled people that go beyond just what the architect and the design team draws in the documents. Indemnification for deviations. What happens if the owner decides to deviate from your design? Are you entitled to be indemnified in the event that they decide to make a knowing decision to, deviate from what you've drawn in your issue for construction documents? There are so many other things that we could have included in terms of custom modifications to the B101 2017 from Article 1 through Article 12. When we get to Article 13, it talks about the scope of the agreement. Here is where you have the ability to include exhibits that talk about what your scope is and what it isn't. You have the ability to include other exhibits to draw lines of demarcation between design services provided by you and design services to be provided by others. And so, there's the opportunity in Article 13 of the B101 2017 to talk about, what is the scope of your agreement, the scope of your obligations, to draw those lines of demarcation. Because if you don't have a duty to do something as an architect, then you really can't be liable for it. Really, like, the duty is the essential trigger for liability, and the clearer you are about what your duties are and are not in the document, the easier it's going to be for you to be able to fight off a claim and say that, like, I can't be liable for that thing because it was never part of my duty to see to that particular issue. And so I hope that this has been helpful for architects. I hope that you understand that this is just the tip of the iceberg, But I will tell you that the B101 2017 Owner Architect Agreement I think is fantastic. I would encourage you to use it. I would encourage you to use it with your eyes open, that it incorporates by reference the A201 2017 General Conditions document. And I would encourage you to make sure that you consider what sort of custom edits are necessary to get you and your owner client on the same page. And, to work closely with your insurance broker and a design professional attorney to make sure that you don't spoil your professional liability insurance with those custom edits that you put into the contract, because that is maybe the most important thing that you can do when you're negotiating an agreement between the owner and the architect, like the B101 2017.